avoid a situation of expending precious judicial time where no jurisdiction exists, as it will render such entire proceedings a nullity. See the case of Ngere and another versus Okurekets the 14th and another 2023 60001 Supreme Court at pages 27 to 28, paragraphs B to A. It is also settled that for the court to ascertain whether or not it is vested with jurisdiction over a matter before it, the statement of facts of the claimant must be considered vis-a-vis the enabling statute empowering the courts. In this case, Section 254C of the 1999 Constitution becomes very much relevant, while it has undoubtedly been re-echoed by the court that the National Industrial Court of Nigeria has exclusive jurisdiction on matters relating to or connected with or arising from employment, labor, workplace, etc. In the instant suit, the claimant has, by paragraphs 5, 8, 31, and 32 of her statement of facts, among others, made reference to some claims of being engaged as an employee of the defendant, and that the injuries she sustained were as a result of an accident that occurred during her employment with the defendant, hence the relief sought thereof. She adequately referred to a letter of engagement which formed the basis of the supposed employment relationship with the defendant, which they now challenge as a consultancy relationship and nothing but a contract for service. As part of claimant's contention against the notice of preliminary objection, her counsel has argued that determining this NPO will indirectly mean determining a substantive issue in limine, praying the court not to allow same. My perusal of the relief sought by the claimant, particularly relief 1, reads thus, and I quote, a declaration that the claimant, by virtue of the letter of engagement dated 20th May 2019, is an employee of the defendant within the meaning of an employee contemplated under the provisions of the Employee Compensation Act 2010, and thus entitled to full benefits, compensation, and all other benefits accruable to an employee with the defendant for suffering from permanent disability as a result of an accident that occurred during the course of employment with the defendant, unquote. It is crystal clear from the above that the issue of the status of the claimant as an employee of defendant has been thrown up for determination and a subsequent declaration as a relief 1. The defendant's prayer in this notice of preliminary objection, which is mainly for a striking out of the suit in limine, is hinged forcefully on the ground that this court lacks jurisdiction, as claimant is not its employee, but an independent contractor. See grounds 3, 4, and 5 of the notice of preliminary objection. Having presented the scenario above, the defendant cannot deny that should this court proceed to determine the merits of this objection as presently constituted, it will certainly mean determining one way or the other claimant's main relief 1, and possibly others by extension. Given that such unpalatable outcome will come to be, I warn myself, as done in a plethora of cases, that the court will not determine substantive issues at an interlocutory stage of trial. See the cases of UBA versus Imaches Nigeria Limited, 2003, 6 Nigeria Weekly Law Report, Part 817, 529, at 543 to 544, paragraphs G to B, and Dehinsilu versus Mondek Pharmacy Limited, 2008, LPLR 3547, Court of Appeal. My conclusion on this objection is that it is incompetent for the reasons stated above and accordingly dismissed. The matter shall thus proceed to hearing, and ruling is hereby entered. So we shall take a date now for, I'll give you a date.
My lord, before we take a date, we are very, very grateful for the well-considered ruling. We thank my lord for the diligence and the industry that my lord have put in delivering this ruling. We are grateful, my lord.
Thank you, counsel. So we'll be considering a date now. Yes, you can look at your respective diaries, counsel. You can check your respective diaries so that we can take a date. I'm
I
looking
don't
at
know
the
if my
date.
I
Yes,
don't know if my
counsel.
Lord can suggest any date for us so that we can.
Look at I'm trying to check the diary. See, we can take a clear date in April. We have no date in April. We may be looking at June. So I'll suggest the available date to you in June.
My Lord, I don't know if my Lord can consider us for May.
May. We don't have
Yes.
any free dates in May. I'm trying to see. The earliest date we can get to be June. So I'll suggest some dates to you in June and you pick from those dates. And if you
Uh,
want 2 dates, we can give 2 dates so that we can get done with this matter. And we have.
as the couple, we will be grateful if my Lord will give us 2 dates
So
so that
the
we
2
can take.
dates now will be 23rd and 24th of June. 23rd and 24th of June. So definite hearing, and I believe within those 2 dates, from the records, I think we have just the sole witness for each of the
Yes, my
parties. Yes, so we should
yes,
be
my
done
Lord.
with the trial within those 2 dates,
As the
23rd and 24th.
Yes, my Lord. It's convenient for us, my Lord.
All right. So upon agreement of both counsel, case is further adjourned to 23rd and 24th days of June 2026 for definite hearing.
As the court pleases.
So claimant's counsel, prepare your witness for trial and equally settle documents for use at trial with the defendant's counsel.
As the court please.
All right. Thank you, counsel.
We are grateful, my Lord.
All right. So the case is adjourned accordingly, and so you can now exit the platform. Thank you.
Thank you, Lordship.
All right.